Thank you for watching this webinar. My name is Eamon Chawke and I'm here with my colleague Michelle Sally. We are solicitors working for BRIFA, which is an intellectual property and information technology law firm based at the Business Design Centre in London. The purpose of this webinar is to explore the new EU data protection regulation, and in particular, to pick out the sections of the regulation that we consider to be key, and those sections that we feel we're going to see substantial changes from the existing data protection law as it stands. So, first, Michelle will give an overview of the regulation and seek to answer the question, what is the General Data Protection Regulation, or what is the GDPR? Next, I will explore the overarching concepts of accountability and the new concept of privacy by design. Michelle will then look at the key concepts in this regulation of consent, parental consent, and sensitive personal data. Next, I will explore the rights of data subjects to make subject access requests and look at some of the other rights that data subjects will have under this new regulation. Michelle will then look at notification obligations in circumstances where a breach has taken place, and I will look at potential sanctions. Michelle will then discuss international transfers of personal data and the significance of the new EU-US Privacy Shield. Finally, I will discuss the significance of the Brexit vote, and Michelle will conclude with a brief summary and some practical tips and hints for compliance.
Moving on from our overview, it might be useful to give you some context on why we're here and the regulation itself. This is one of the most significant pieces of legislation to come from Europe. There has been much change since the 1997 directive on the same topic of data protection. In 1998, we saw the creation of Google. 2004 saw the launch of Facebook, and 2006 the launch of Twitter. As such, it's no surprise that the law is playing catch-up with technological advancements. The 1997 directive on data protection could be implemented in our own way. As such, we had some flexibility when we implemented our own act, the Data Protection Act 1998. The General Data Protection Regulation is a regulation. This is an important distinction. It is effective, directly effective, in member states. It is also not open to interpretation. Compliance will be mandatory. So what is the aim behind the regulation? Well, it's designed to harmonise member states so we all comply with the same law. But it doesn't just apply to EU countries. It has a vast territorial reach. So if you're a company based outside Europe and dealing with EU citizen personal data, this law will apply to you. The law will come into force in May 2018, so that gives us a 2-year transition period. This means we can stagger our compliance over the next 2 years, rather than make a huge jump in 2018.
Turning now to consider the question of accountability, the overall aim of the data protection regulation is to impose obligations on entities that process personal data relating to individuals. So it's worth considering at this point two things. Firstly, on whom are these obligations imposed? And secondly, to whom are these obligations owed? So, a data controller is an entity who makes decisions about the processing of personal data. So for example, your business. A data processor then is an entity who processes personal data on behalf of the data controller. So for example, your outsourced payroll or your outsourced human resources function. Now it's worth considering these two entities because under the current data protection law, all of the obligations are imposed on data controllers only, whereas under the new regulation, obligations will be imposed both on data controllers and on data processors. The last stakeholder to consider then is the data subject, and the data subject is the entity or the individual person in respect of whom these obligations are owed. In addition to the overarching concept of accountability, this regulation has also introduced a new concept of privacy by design, or data protection by design. In other words, rather than setting up your business first and then considering afterwards how you're going to comply with your obligations under this regulation, the regulation obliges you to consider from the outset and to incorporate into your business at all stages how you are going to comply with privacy by design and how you're going to comply with your obligations under the regulation. And what the regulation requires of you is that you implement organizational and technical measures to ensure this compliance. So, examples of these organizational and technical measures might include ensuring that your staff have received data protection training, ensuring that your business has a data protection policy in place and that this data protection policy has been made available to the relevant data subjects, for example, your customers and your employees, ensuring that a clear and accessible system is in place for customers and employees to make subject access requests, which we'll discuss later, and ensuring that this system has been brought to the attention of your customers and your employees. It's also necessary to ensure that appropriate technical measures are in place, such as the encryption of data and ensuring that passwords are changed regularly. Another potential organizational measure is the appointment of a data protection officer, somebody within your organization who's responsible for data protection and for ensuring compliance with this new regulation. Another requirement that is specifically mentioned in this regulation is that businesses should conduct a privacy impact assessment or prepare a privacy impact statement to assess data protection compliance before any system is implemented or before any project is undertaken which might carry a particularly high data protection risk. Ultimately, your aim as a business should be to protect the personal data of your data subjects, but also to protect yourself, so that if a data breach ever does occur, you're able to demonstrate to the relevant data subject and to the Information Commissioner's Office, which is the supervisory authority in the UK, that you have sufficient organisational and technical measures in place to comply with your obligations under this new regulation.
Leading on from this privacy by design approach, we'll look to the specific requirements of the General Data Protection Regulation. The first topic for discussion is consent. The provisions in relation to consent have become much stricter, with the burden of proving lawful consent on the data controller. Consent must be freely given, specific, informed, unambiguous, and revocable. Consent must also be given by affirmative action. Let's take each of these in turn. Consent must be freely given. This means it cannot be conditional on a contract or providing a service. Consent must be specific to a data processing operation. This means if you ask for consent for a specific purpose and decide to use the data for a new purpose, you must ask for new permission. Consent must also be informed and unambiguous. It must there be requested in clear and plain language, so the data subject understands why you need the personal data. Consent must also be revocable just as easily as it was given. Lastly, consent must be expressed either by statement or clear affirmative action, such as ticking a box. Pre-ticking boxes or silence will no longer constitute as consent. There is an added layer of consent in relation to children, limiting the ability of children to give consent without parental authorization. In relation to sensitive data, a subset of personal data, this category has been expanded under the new regulation to include genetic data and biometric data that identifies an individual.
In terms of the changes that we've seen coming through under this new regulation over the existing law, firstly, a data subject access request must now be processed free of charge, where previously data controllers were allowed to charge data subjects an administrative fee for making that information available. Secondly, a data subject access request must be processed without undue delay, and in any event, it must take no longer than 1 month to process. There are a number of exceptions to the right for a data subject to make a subject access request. First, an exception may be made where granting the request would prejudice the intellectual property rights of a third party. So, for example, in relation to trade secrets or certain confidential information. Second, an exception may be made where a data subject requests a particularly large quantity of data or information, in which case the burden then shifts to the data subject to specify the information or the categories of information which they require. Thirdly, an exception may also be made where the disclosure of information would prejudice the rights of a third party. However, a data controller cannot use this reason as a blanket refusal. Instead, they have to disclose such information as would not prejudice the rights of third parties. In terms of the other specific rights that are granted to data subjects, which complement the principal right or the basic right to make the access requests, data subjects also have the right to request rectification. In other words, to require data controllers to correct any errors in their personal data. Data subjects also have a new right under this regulation of portability. And this new right goes beyond the existing right to merely receive a copy of their personal data, because the portability right requires the controller to make the information available in a technical, structured, and machine-readable form. And data controllers can also be required to transfer the information in that form to another data controller. Data subjects also have the right to object and to prevent the processing of their personal data in various circumstances. In some cases, the right to object is absolute, and in some cases that right is qualified. One of the principal rights to object is the right to object to direct marketing. And where processing will take place for this purpose, data controllers must inform the data subject at the outset, and they must also inform the data subject of their right to opt out. Another specific right granted under this new regulation is the right to be forgotten, which gives statutory footing to an existing right which had already been identified through EU case law. The right to be forgotten basically provides that data subjects can request that their personal data be erased or deleted in certain circumstances, such as where it's no longer necessary that the information be processed because the original purpose for the processing has now expired. Another example is where the data subject has withdrawn their consent and there is no other legitimate purpose for the processing to continue. There are some exceptions to the right to be forgotten, such as reasons relating to public health and reasons relating to freedom of expression. So that gives you an overview of the rights that data subjects have under this new regulation. And the key point to consider is the interplay between the substantive rights that the data subjects have and the obligations that are imposed on data controllers and data processors. Because for every right that a data subject has, whether it's the right to make an access request, the right to object, the right to rectification, and so on, for every substantive right, there's a corresponding and a reciprocal obligation on the controller and the processor to put sufficient organisational and technical measures in place to give effect to those rights.
Another operational change relates to notifications in the event of a data breach, i.e., a breach of security which results in the accidental or unlawful destruction, loss, alteration, unauthorised disclosure or unauthorised use of personal data. There is no need for the breach to result in identity theft or fraud. It is enough that there has been an unauthorised disclosure of personal data. If a breach happens, the data controller must inform the supervising authority without undue delay, or within 72 hours of awareness of the breach. The data controller may also be required to tell the data subject if it affects their rights and freedoms. There is an exclusion or a get-out clause. Notification may not be required if it does not affect the rights and freedoms of the individual. This allows controllers to assess the risk and decide whether notification is necessary. If a data processor is responsible for the breach, they must inform the data controller. The data controller must then tell the supervising authority and potentially the data subject. In any event,
Turning now to consider the questions of sanctions under this new regulation, this is probably one of the most significant changes and one of the most significant moves away from the law as it stands. And there's two things to consider here. Firstly, we need to consider the remedies that are available to data subjects. And secondly, we need to consider the administrative fines that may be imposed by the supervisory authorities. And in the UK, that's the ICO, or the Information Commissioner's Office. So firstly, looking at the right that data subjects will have under this new regulation. Firstly, data subjects will be able to lodge a complaint with the supervisory authority, or the ICO, and complain that their rights have been breached under the regulation. Secondly, data subjects will have the right to issue legal proceedings, not just against the data controller, but against the data processor and against the ICO itself. And thirdly, data subjects will have the right to seek damages or financial compensation from the data controller and the processor for any damage or any loss or any injury attributable to the breach of their rights under this regulation. So that's the first aspect, the rights of the data subject and the liabilities of the controllers and the processors. The second point to consider, and arguably the much more significant point and significant change under this new regulation, is the fines that may be handed down by the supervisory authorities or by the ICO in the UK. And there are two tiers of breaches here, a lower tier breach and a higher tier breach. For a lower tier breach, an administrative fine of €10 million or 2% of worldwide annual turnover may be levied. And for a higher tier breach, a fine of €20 million or 4% of worldwide annual turnover may be levied. Now, an example of a lower tier breach would be a failure to implement proper organizational and technical measures or to ensure privacy by design or data protection by design, as we've already discussed. An example of a higher tier breach would be a breach in relation to an international transfer of data or a failure to comply with an order already given by a supervisory authority. It is worth noting that these fines are discretionary and the supervisory authorities will take various factors into account when deciding whether to levy the fine and when deciding the level of the fine to be imposed. However, considering that the maximum fine under the current data protection law is £500,000, this is undoubtedly a significant change. And clearly, this significant change is intended to disincentivise a lax approach to data protection compliance and to encourage or inculcate or incentivise privacy by design and data protection by design right across Europe.
When transferring data outside the European Union, you must comply with the international transfer provisions of the regulation. Transfers are restricted unless the European Commission has made a finding of adequacy, there are binding corporate rules in place, or standard corporate clauses in place, or you have the consent of the data subject. So let's take each of these in turn. In relation to adequacy, the European Commission will make a finding of adequacy if the country has the same or stricter rules in place in relation to personal data. Binding corporate rules are rules between multinationals in relation to intergroup transfers. Standard corporate clauses are contractual clauses normally between data controllers and data processors that places obligations on both parties. Lastly, consent. You need the consent of the data subject, which we have discussed earlier. So if we cast our mind back to adequacy, the US had an agreement in place with the European Union to allow for personal data to be transferred to the US without issue. This was known as the Safe Harbour Agreement. However, in 2015, a court ruled that this agreement was no longer adequate and did not protect personal data of EU-based citizens. So we were back to square one. Despite this, in 2016, we had a new agreement offered to us, the Privacy Shield. This Privacy Shield put stronger obligations on the US to protect personal data and give EU-based citizens redress options if their data was misused. Although there's a lot of talk about this at the minute, this agreement is yet to be finalised.
Turning now to consider the significance of the Brexit vote. The decision taken by the majority of the voting public in the UK that Britain should leave the European Union has obviously come as a shock to many in the UK and as a shock to many in the EU. And it has left a lot of people wondering what now will be the significance of EU law in the UK, or will it have any applicability at all? Well, the first point to make about this regulation is that its implementation date has already been set for May 2018. And the secession date, or the date on which Britain will actually leave the EU, will be 2 years from the commencement of the Article 50 procedure. So even if that procedure is commenced at the end of 2016 or at the beginning of 2017, the earliest possible date that EU law might cease to apply in the UK would be early 2019. In other words, businesses will be obliged to comply with EU law until early 2019. The second point to make is that even if UK businesses are willing to risk non-compliance with this regulation between May 2018 and the beginning of 2019, this regulation specifically provides that it will apply to non-EU businesses and non-EU processors and controllers in certain circumstances. So first, where non-EU processors or controllers process personal data in relation to EU citizens, they will continue to be obliged to comply with this regulation. Second, where controllers or processors not in the EU make goods and services available in the EU, they will continue to be obliged to comply with this regulation. And finally, where non-EU controllers or processors monitor the behaviour of EU citizens, they will still have to comply with this regulation. So in short, while the applicability of EU law in general has been brought into question as a result of this Brexit vote, this regulation cannot be ignored for the two reasons already explained.
In summary, we have broadly discussed the incoming changes of the General Data Protection Regulation and the implications of Brexit. We will need to comply with this new law. As such, we've added some compliance tips for the short term. Number 1, know your data. Carry out a data mapping exercise. Know where the transfers occur and if there are any risks of a data breach. Number 2, review your existing data protection policies, your codes, and any internal training. Ensure your staff know where data breaches might occur and the new rules of the regulation. Number 3, identify ways to demonstrate compliance. Ensure you have a paper trail and any updates to security is monitored. Number 4, identify the ways you obtain consent from your data subjects. Ensure you're compliant with the new data protection regulation. And number 5, identify any international transfers. This will be helpful when you carry out your data mapping exercise.